Democratic Senator Elizabeth Warren and AOC are calling for changes in the world of deal-making during this pandemic. The duo introducing an anti-monopoly act last month that calls for a freeze on mergers by companies with revenue of over $100 million or more, as well as some hedge fund deals. That would be until the FTC determines small businesses, workers, and consumers are no longer under severe financial distress. Joining us right now in an exclusive interview to talk about this idea and so much more that's taking place in corporate America, Makan Delrahim is Assistant Attorney General for the Antitrust Division at the Department of Justice, the man in the middle who ultimately makes decisions about the futures of mergers in this country. Makan, it's great to see you. We appreciate you joining us. Before we get into some of the larger issues that are taking place in corporate America around consolidation during this pandemic, I did want to get your thoughts on this bill and the idea that there are folks in Washington who think that during the pandemic, transactions should be stopped.
Well, good morning to you, Andrew, and thanks again for having me on. We haven't seen the legislative language, so we don't have any official position on it. However, I think it would be misguided to just block all attempts for transactions. There's no question that the crisis has created some real challenges for the work at the division. But, it's an old saying in a great book a few years ago, I think it was called The Unfinished Leader, that for every complex problem, there's a very simple solution, and it's wrong. And here, I don't think we should be using the crisis to just block all sorts of pro-competitive and probably some transactions that will be very necessary during this time to make sure that companies have the liquidity to continue on and keep workers employed.
Well, let me ask you about that, whether the bar changes during the pandemic. You talked about necessary, and there are going to be companies that are genuinely challenged businesses that might not have been challenged just months ago, where two companies coming together, you might have looked at those two companies coming together and said, this is too much consolidation. How does that change in this environment for you?
So, the legal standards are the same, but what's great about the way we work and how antitrust law works is it provides the flexibility to deal with these exigent circumstances. So, we've recently reviewed, and I made some public comments about how the current crisis affected that transaction, was when the Dairy Farmers of America bought, I think it was a $400 or $500 million transaction, the assets from Dean Foods, and then a separate transaction for some other assets of Dean Foods by Prairie Farms. And we had to look at those because the current challenges for, demand of milk with the schools closing and restaurants closing was down. So those were real effects. But, there's been an established three-part test that businesses would have to meet for us, under what's called the failing firm defense. The company would have to be, has to be unable to meet its financial obligations in the near future. They can't reorganize and shed off the debt through a bankruptcy proceeding. And there actually has to be some kind of a good faith effort that's been unsuccessful to sell the business or the division or the assets to a less anti-competitive or less competitively restrictive buyer. So ultimately, what we look at, as we do in normal times, is the customer, is the consumer worse off after the merger than they would be if we blocked that merger.
Okay, let me test one out on you. I know you don't like to talk directly about companies, but let me just try this. There's been reports that Amazon is looking at AMC, the film movie theater owner, of course, across the country, that is now a genuinely challenged business and is likely to be a genuinely challenged business at least for the next 12 months, if much longer. How would the Justice Department look at a transaction like that?
So, you're right, is that I can't comment on any potential pending deal if the rumors are correct. I think the movie exhibition industry has gone through some challenges over the years, just with the high capital expenses that they must continue to put in. And the movie theaters have been shut down, like theme parks. So we would look at it again under the same three-part test. Should that be a defense to the merger. The merger itself, under normal analysis, may not pose competition concerns. Again, not commenting on this specific deal. So, the men and women of the Antitrust Division will take a look at all the facts, and a failing firm defense of AMC may very well not be necessary. So we would look at it, but we would look at it quickly under these circumstances. The process has been challenged. We can't really take depositions of witnesses, meet in person like we have done. That has been very useful. But otherwise, we will look at it through the same fact-based analysis that we normally do.
What about the idea of national champions? And the reason I ask it is, in this age of the pandemic, one of the lessons we've learned is that we want to bring more of our supply chains, manufacturing, everything else back to the United States. We need to become much more resilient and reliant on our own facilities and abilities inside this country. And to make that happen, there are lots of business people and policymakers who say we need to allow more mergers to take place, especially when you have homegrown giants in places like China and elsewhere. Is that going to change the dynamic in terms of the thinking of your department?
Well, I think there's no question that the challenges of the supply chain and how we look at it from a national security standpoint and strategic supplies that we will need in the United States, and this White House has been looking at that, is going to be an important element going forward for some of the critical areas. Antitrust law does not factor, specifically the national security concerns. We have a different regime going through the CFIUS process that was recently updated, through which we will take a look to see if there's any foreign investment. And related to that, I should also say that when the government directs certain types of activities, there's doctrines that would immunize those types of activities by the private sector, who will be working with the government and under the direction of the government from antitrust scrutiny.
What about the travel industry? Obviously, airlines are hard hit. There's been a lot of consolidation in that industry already. Some people argued, at least prior to this, that there was too much consolidation in that space. You're also seeing it on the other side of the travel reservations. The department blocked effectively a transaction involving Sabre. You look back at that now, both of those companies now may be very challenged businesses.
They could be. I think we would all hope and guess that the travel industry will be back in full force once we're on the other side of this current pandemic. But Sabre is a good example. That was one where we actually made a filing yesterday to vacate the lower court's opinion, which was wrong on one element. But the facts might change, as they always do. So every situation will allow us to look at the same standards. We don't, in the Antitrust Division, I think people can take comfort. We don't stick our heads in the sand and just assume that we are going to apply blindly a particular standard or get in the way of business. I think we're all challenged to work together to make sure that we are getting out of this and get the fastest recovery for the economy.